I'm Ron Walker, Director of Legal Affairs with the Texas Association of Realtors. About 4 years ago, the Department of Housing and Urban Development investigated and entered into settlement agreements with a number of title companies in the Austin area for alleged violations of the Real Estate Settlement and Procedures Act, also known as RESPA. HUD alleged that these title companies violated RESPA by giving free items, such as virtual tours, to realtors. The fines were rather significant. It has been well settled for many decades that RESPA prohibits settlement service providers from giving each other things of value in exchange for the referral of business. About 18 months ago, the Texas Department of Insurance adopted a rule known as Rule P53. The rule built on HUD's enforcement actions and was adopted to help eliminate several other questionable practices related to promotional activities by title companies. The intent of the rule was to stop a title company from paying the business expenses of realtors, builders, attorneys, and other persons who were in a position to refer business to the title company. The rule calls such persons producers. The rule appropriately stopped title companies from providing free flyers, signs, and otherwise paying for business expenses of producers. After P53 was adopted, a number of questions arose about how far P53 extended in terms of limiting a title company's ability to promote itself. The interpretations related to P53's applicability had a chilling effect on whether a title company could purchase bona fide advertising or whether a title company could engage in bona fide promotional activities at association events, charitable events at which producers might be present, or other types of activities. In response, the Texas legislature passed a bill that helps clarify a number of questions related to P53's applicability. The governor signed the bill. The bill is based on common sense principles of commercial free speech and the freedom of association. Simply put, the bill states that a title company may engage in legal, promotional, and educational activities. It also states that a title company may purchase advertising that promotes the title company from any person or in any media as long as it pays a market rate for the advertising. It also states that a title company may deliver to a party or an agent in a transaction documents or funds related to the transaction. For example, the title company can deliver copies of the contracts to the parties or their agents and deliver commission checks to the parties or their agents. And finally, the bill states that a title company may participate in association activities as members, provided that the title company does no more than the typical volunteer member would do in the association. The bill should address a number of questions and help eliminate much confusion. We anticipate that the Texas Department of Insurance will amend P53 soon to remain consistent with the new law. We need to thank the governor for signing the bill. We also need to thank all of our legislators for their assistance, but especially we need to thank Representative Craig Island, Senator Eddie Lucio, and Senator Todd Staples for this particular measure.